Hello, and welcome to Law Talk. My name is John Celebrezzi, and I'm the co-founder of the Celebrezzi-Zangi Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important
Susanna
legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezzi, who was the popular five-term mayor of Cleveland and a member of President Kennedy's cabinet. As a tribute to his lifetime commitment to the legal process, we dedicate this show.
Unruly, misdemeanor, and felony cases. Prior to her appointment as magistrate, Susanna served as an assistant prosecuting attorney and as counsel to the Stark County Department of Human Services. She holds a bachelor's degree from Kane College in New Jersey and has a law degree from the University of Akron. She is married with 2 children and resides in Medina County. Welcome, Susan.
Hi, thank you very much for having me.
Well, thanks for being here. Maybe many of our viewers don't really understand what a magistrate does, and actually, in all fairness to them, I was a teacher and a school administrator for a number of years, but it wasn't until I involved myself with the courts that I was introduced to magistrates. And by the way, when you're a lawyer, you get to see magistrates, pretty often, actually more often than you see the judge. So my first question for you, and just kind of an opening question so you could tell the folks, what you do and what magistrates do. Can you explain the functions of a court magistrate, Susanna? Maybe in comparison and contrast to that of a judge?
I think that is the absolute #1 question I get when people ask me what I do, or friends that really don't know the difference, and I think it's a common question. Essentially, magistrates are appointed by the judge, and judges are elected officials. However, magistrates are not. So you are appointed by the judge of your court at his discretion. Although magistrates do handle the day-to-day functioning of the court just like a judge would. We preside over trials and pre-trial status hearings, sentencing hearings, what have you.
So you do all the stuff judges do. Right?
You do. I mean, in certain cases, magistrates may hear jury trials, but that's more rare.
I see.
For my job as a juvenile court magistrate, we generally don't have jury trials.
Sure.
However, I think a pivotal difference between a magistrate and a judge is that magistrates' decisions are not final until they are adopted by independent review by a judge.
I see.
So generally what would happen is, let's say I conducted a trial, I issued my decision following the trial like a jury would. I would rule on evidentiary matters during a trial like a judge would.
Sure.
Issue a decision, and then the judge would independently review it and decide to adopt or not adopt it. In the in-between following my decision, a party in a case has 14 days to disagree by objecting to my decision.
You hear a case, just exactly like a judge would, and even a juvenile court judge alone, in juvenile matters, there's no jury anyway, correct?
Generally not.
Generally not, okay. On the probate side, which is the other thing that he does, there are juries.
There are.
But in your case,
there may be. It's rare, but there may be a jury trial.
But for the most part, much like domestic relations, there's no jury in domestic.
What's interesting about juvenile court, not to interrupt you, but sometimes we have jurisdiction over adults, like say and contributing to the delinquency or an unruliness of a minor, and in those cases, and that's why I say generally,
there you go.
You would have the right to have a jury trial.
Well, that's an excellent point. Yeah, so my comparison to domestic is not really...
It's very close. So.
Close, but it's not on all fours, because a contributor, an adult who contributed to the actions of a juvenile, that case might wind up with a jury.
Yeah.
Okay. But in your case, you've made a decision about a youngster, a juvenile. The judge independently reviews it. If he is in agreement with your line of thinking, you've used all the same skills as a judge in putting your recommendations together. There you have it. If I happen to be the lawyer who represents the child, and in that interim period of two weeks, I guess I just file a motion. Is that?
You would file an objection to a magistrate's decision, and then in most cases, let's just generalize it, you would need a transcript of the proceedings,
Okay.
which is all the words that we say in court,
Sure.
typed up in the form of a written document that the judge then can review to see exactly what happened in the court hearing, and then he reviews it, and then if there's opposing counsel, let's say if you represent the child, the prosecutor may file a response to your objection.
Sure.
And then the
Okay.
judge he has the option of doing many things. He can adopt the decision, he can not adopt the decision and then remand it back down to the magistrate. He can hold a new hearing, a de novo hearing on it.
Meaning he'd just do it himself?
Do it all over again.
Okay. All right. Well, that clarifies. It's a word that in the legal community is thrown around all the time, but magistrate, for the benefit of our viewers, is somebody who really does everything a judge does, but there just are some safeguards there, if you want to call them safeguards, I guess it's a fair answer,
Right.
that the litigants could take it back to the judge. When an objection's filed, Susanna, does that always prompt a hearing?
Not necessarily. It can be done, if a party wants a hearing on objections, they can request it. And some courts, as a matter of course, do schedule for oral
Okay.
arguments, so to speak, or a hearing on it. But it doesn't necessarily have to be the case. It's really at the discretion of the court and at the request of parties.
I see.
So it can be done just with the record. In other words, that transcript and the written motions and
Sure.
responses, what
It's
have
all
you.
there.
The court can just review the writings and decide, or the court can decide, and generally you would have a motion by a party to hear it, to actually argue it in court, like you would in the 9th District.
Yeah.
Sometimes if you have an appeal, parties do waive oral argument. And sometimes they submit it on brief, so you could do it one of both ways.
What's, as a practical matter, Susanna, lawyers, I'm sure there's nothing personal or anything. They're just advocates for their clients, and you came down on one side, they would have preferred to see you go down on the other side.
Mm-hmm.
Is it the norm to ask for a hearing, or for the most part, we just make our objection and let the transcript speak?
I think it's about a 50-50 split.
About half and half?
I think so.
Okay.
Yep, I think it depends, like you said, on each lawyer and how they feel about wanting to actually present their case,
Sure,
and whether
sure.
they feel comfortable just with the record or actually want to enhance the record with their own statements directly to the judge of the court.
So probably half and half.
Mm-hmm.
And in your case, and I guess in all magistrates' cases, at least at the state courts, you pretty much work at the pleasure of Judge Loan.
Yes.
He appointed you, and you worked for...
Exactly.
Okay. To become a judge, if I'm correct, you have to practice law for 6 years. Is that true to become a magistrate?
It's interesting. With magistrates, there is no set number of years that you have to practice law.
I see. That's interesting.
So it's different than that. Although we do have a magistrates association, the Ohio Association of Magistrates,
Sure.
And the average tenure of a magistrate is about 20 years for a full-time magistrate. So people that are acting as magistrates throughout the state of Ohio, on average, they have about 20 years experience. That's not to say everyone, but just as an average figure, and there is no minimum requirement.
Well, on its face, and doesn't really have anything to do with politics per se, but as far as quality of judicial candidates go, I would have to assume that people who sat as a magistrate for some time would be very well prepared to be a judge. That's a pretty fair statement, isn't it?
I think so. I think it really does prepare you for those things. Obviously, it's the best training you can have,
Sure.
because you're conducting trials just like a judge would, ruling on evidentiary matters, you're applying the law, you're actually getting comfortable with, just with the world on the other side of the bench versus a lawyer, who is actually addressing the court and being on the other side.
I throw it out, and there's been a lot of discussion. There has been for years and years how judges are selected. Some people think they should be appointed. Some people think they should be elected, as they are now. Mm-hmm. It's allegedly a nonpartisan ballot, but that really doesn't happen until the general election. Mm-hmm. But the word magistrate, and I think our viewers would, the whole purpose of CZ CLEP is legal education. If you were seeking information about a candidate, it would be well for them to know what the magistrate does as to making their decision how they want to vote. And you've done a nice job there. I guess I threw out the 6 years, but are there any other training requirements?
Well, you have to maintain your license in the state of Ohio.
You have to be a lawyer.
You have to be a licensed attorney in the state of Ohio. And there are no, aside from your continuing legal education credits that we have to get just like all other lawyers, really there is no specific requirement. I think the real life requirement is what you broached upon, is the fact that I think to be a good magistrate and to do your job effectively, you really have to have a grasp on trial practice and procedure, because you're going to be called upon to do trials. And so that, you know, you should have some practice, even though there is no minimum requirement. I think that most judges look to that to make sure that
when they make their
choice, appointments and choices. I think you would have to have experience like any other job would.
So to sort of personalize this, because we're fortunate enough to have you with us today, your specific training to be a magistrate pretty much came from the introduction I read from you. You are a University of Akron Law School graduate. You took the bar what year?
1990.
1990. So you've been practicing in the field for a decade now. You mentioned the Magistrates Association. We all have to do CLEs, and for the benefits of our viewers there, CLEs are continuing legal education. Lawyers have to have X number of hours to keep their license. And does your Magistrates Association sponsor those things for you guys?
They do. They actually do run some continuing legal education credits. The difference between attorneys and magistrates and judges is that we go through the judicial college, so they're more geared towards the other side of the bench, whereas an attorney would, get continuing legal education credits and, in practice and procedure. Some of the credits that we can attain are more along the lines of judicial practice and procedure. It's the same requirements are met, and the Magistrates Association puts out a spring and fall conference, which are really effective.
This association is probably a great tool, a great help to folks who hold your position.
It is.
Okay. Do all courts, Susanna, have magistrates?
There are no requirements, Mr. Celebrezzi, for courts to have or not have magistrates. It's completely at the discretion of the court. But within our technical, neighboring counties, I would say that most courts do have magistrates. Municipal, general division courts, including juvenile, probate, most courts do have magistrates. There are no requirements. Some courts, probably if you look at some of the outlying counties, you might find that some courts have more judges, no magistrates.
It has to do with workload.
It does. Yeah. I think that magistrates do effectively assist in the operations.
Other than you, with Judge Lone in Medina, we have juvenile, probate are all one division of the common pleas court there. Other than yourself, are there other magistrates that work for Judge Lone?
Yes, there are.
Who are they?
A total of 4 magistrates. We have Matthew Kane, we have Chief Magistrate Russo, and Lori Brobst. And the 4 of us work together on these cases. Generally, Magistrate Brobst is assigned to probate matters, but she does also do delinquency, unruly, and traffic. And then Magistrate Russo, Magistrate Kane, and myself, we generally divide up the traffic cases and the delinquency cases and the unruly charges. Judge Lone generally hears the dependency and neglect cases himself. And so he generally takes on that responsibility himself.
Busy place, isn't it?
Yes, it is.
You sort of have both ends of the spectrum. You have from birth to age 18, and then when we pass, you have that end of